Business Law, Chapter 10, we get to talk about torts. And torts, maybe you haven't heard that word being used a bunch, but that's a very common term. Of course, we hear, and I think your assignment was about tort reform. We hear about tort and tort reform often. And what that involves is, we all have as we go about our daily activities, a duty of care. And if we fail in that duty, whether intentionally or negligently, we may be subject then to lawsuits, right? Which that whole process basically is called torts. And as we go through, kind of keep it simple. There's three main types of torts. Know these. There's intentional, negligent, and strict liability. Negligent is by far the most common. Okay, and intentional and strict liability, though, we'll certainly talk about because there are good examples of those. So, definition, and of course you need to know the definition, right? It's a civil wrong other than a breach of contract. So we've got contract law, which we kind of deal with separately, right? Even though, some of the same things. I mean, a breach of a contract is kind of like not exercising a duty of care, but contracts are their own creature, and we deal with them separately. Tort laws limit, right, how people act and how we use our resources. It's one of the main reasons we say that, property rights and those types of things aren't limitless, right? We do put some limits on those types of things. So, tortious behavior results in tort. And again, that could be intentional, negligent, strict liability we'll talk about. Now this is extremely negligent. That's beer. It's obviously it's a German beer, I believe, or Netherlands or something over there, Grolsch. And it's all gone to waste. Look at that. Tortfeasor, one who commits a tort. I've plugged this into like Google and whatnot, and it doesn't come up with anything. And so this must be one of those legal terms that's in our book and probably in legal libraries, but maybe not so much otherwise. Maybe you can find it now. I haven't checked for a few years, but again, the three types of tort: intentional, negligent, strict liability. Keep it kind of simple. Maybe do that in your notes, and then kind of go from there, right? The types of tort cases, well, the most common, and we just talk about it often, is automobile accidents. Automobile accidents happen, in Havre, there's probably an average of one a day, right? Whether they're big ones or small ones. I mean, it might be as simple as backing your car into another parked car, right? It leaves a scratch on the bumper. Technically that's still, a tort situation, right? Dangerous property, think the old slip and fall, right? You walk into the grocery store and then the floor's wet, and in spite of all the signs and everything, you slip and you fall. Guess what, right? Product liability. These are some of the ones that we probably hear as much about. Okay, poorly manufactured, or in some other case, let's look at the Volkswagen case with their diesel engines and designing them to pass the test even though they actually didn't. Medical malpractice we hear a lot about, and then toxic substance. And I'm not sure if that's, I don't know how they broke this down necessarily. I'm not sure if that is similar to product liability, and this deals with like pharmaceuticals and whatnot that ultimately cause side effects, that are harmful. I'm not sure, or if this has, some other thing. It could be misuse of pesticides or herbicides or things like that. How are they disposed, right? Again, 70% agreed upon settlement. Go back to the car accidents, and how often do you hear of a car accident actually going to court? Not the legal part of it. Sometimes those do. If you're speeding or whatever, you might get hauled into court, to plead guilty or not guilty and write your check to the judge or the court. But the actual that's the criminal side of it. Okay, but the civil side of that case then is making sure that the person whose car was damaged, that shouldn't have been damaged, right, that didn't cause it, making sure that they're made whole, that their car's fixed. And those seldom go to court. Okay, big ones do, maybe that involve death, dismemberment, paralysis, those types of things. Those will often go to court, but again, the most common type, you're backing out. You slide through an intersection. My wife did this a year ago, right? She kind of slides through an intersection on an icy road and hits another gal. Okay, boom, our insurance covers it. We didn't even hear from them. Okay, so it was an agreed upon settlement, right? The insurance just took care of it with the other person, and we didn't even have to worry about it. And then, granted, it was kind of like the backing into them. It was not a major thing. It wasn't a big event. Dismissed. Okay, so judge looks at it and says, yeah, nothing there. Jury verdict, bench trial verdict. Look at how small those are that actually go to court. And then unknown. What's unknown? Well, that's when settlements are made, and nobody talks about it. They don't have to, right? Yeah, they just agree on something and nobody tells anybody, and both parties leave and they must be satisfied. Or, maybe it takes too long and one party just gives up. An intentional tort, right? It's a deliberate action that causes injury. Okay, remember, torts are not the criminal side. Okay, and cases, as we'll see, we'll go through some of these cases, can certainly have both a criminal and a civil side to them. Okay. So, deliberate action, right? Either a desire to bring about certain results or that the results are substantially likely based on those actions. Okay, there has to be intent. For something to be intentional, imagine that, there has to be intent. So examples, right? Assault and battery, okay? And make sure you know the difference between these, okay? And that's probably on the test, the difference between these. That assault is the threat of physical action or physical harm, okay? And the other person believing that threat to be imminent and believing that threat to be actual, real, okay? Battery is the actual physical action, okay? So when I think assault gets used as a generic term to also represent the actual physical action, but in a legal sense and in a tort sense, when we talk about assault and battery, assault's the threat and battery is the actual infliction of the physical harm. Okay, infliction of mental distress, and that can happen. Again, a lot of times some of these things happen with like older adults. Spouses maybe, boyfriend, girlfriend, where there's not actual physical harm, but there can be, mental stress or mental distress caused by somebody's actions or, their words. Invasion of privacy, and this one has taken an much expanded role because of the what's going on. I mean, with the internet and emails and all those other things, think Julian Assange and WikiLeaks, right? No doubt that whoever is tapping in and getting that information, hacking in, I should say, is doing something that's very illegal. That's an invasion of privacy, whether it's a senator, a secretary of state's president, or whether it's a government or whether it's personal stuff, right? It's still an invasion of privacy, okay? And it's illegal, Now, on the government side, should some of that stuff have been public? Yeah, maybe. So it gets to be kind of an interesting gray area, I guess you would say, although, the act of hacking into it and getting it that way is still going to be illegal, right? If you want those documents, you should file the Freedom of Information request like some organizations have been doing. But on a personal basis too, or people getting into your bank account or those types of things, getting information, maybe it's school records or something, right? And getting your Social Security number and those things, from an invasion like that. So lots of this is happening, right? False imprisonment and malicious prosecution. And I think the book says, and it's probably right, that false imprisonment, the most often that might happen is in shoplifting cases where, a store detains somebody and maybe they do it erroneously. Maybe they don't have good proof, that the individual in question actually intended to or did swipe something, right? And so they hold them, and maybe they hold them for too long, and maybe they do wrong things, while they're holding them, whatever the case may be. That could be false imprisonment. And then malicious prosecution, it would be often legal authorities then, the legal system, maybe going after somebody for something that they didn't do, and doing it maliciously. There's one thing, if you think somebody's guilty of something, and you try to prove that in court, that's okay. But if you just don't like somebody and you hate them, and so you go after them, for that reason, that would be malicious prosecution. Trespass. And trespass we often think of as real property, and that's true, but it can be trespass to personal property too. If I'm sitting in your car smoking a cigarette or a cigar or something, maybe a stogie, that would be considered a trespass, right? I mean, your car, your place doing that, okay? And so it can be either or. Trespass can also be things like it might be trespassing if I'm putting weed killer on my lawn and it seeps over onto your lawn, okay, and kills your grass or something because maybe I do it inappropriately or whatever, right? That could be considered kind of a trespass as well. Conversion is using somebody else's assets, and the book explains here that even embezzling and doing those types of things is a type of conversion. It's a theft and a type of conversion, and of course the criminal side of that is the theft side. So the tort side of that would be the conversion. And I often think about this and what I saw in bank. People that were entrusted to maybe handle the affairs of somebody else. For some reason, maybe the person was unable to mentally, physically, they were getting older, whatever the case may be, and rather than use the funds for that person's good, they instead used the funds for their own good. Decided to use it to take a trip to Hawaii instead of using it to care for, their mom or pa or aunt or uncle or grandpa or grandma or whatever the case may be. Defamation. And I don't know how deeply we get into defamation here, but we probably need to discuss it because defamation can be both libel and slander, right? And you need to know the difference between those two if I don't have it on there. But slander is spoken defamation and libel is written defamation, and those are important. Because you can't say or write something about somebody that's not true that causes them economic or other harm. Okay, it's just not right. If it's true, that's fine, right? There's nothing wrong with expressing the truth, but if you're saying things, about a person that's not true, yeah. Okay, then we have a defamation problem. A case, and I remember this one because it was a Montana case, and it was really kind of interesting, and of course, C.M. Russell's a famous painter in Montana, from Montana, and one of his contemporaries, kind of another painter at that time, was a guy named O.C. Seltzer, and O.C. didn't get the kind of fame that Russell did, but he was a Western painter of some renown, and I'm sure you could look him up, but O.C.'s son or grandson, I can't remember which, himself was not a painter, an artist, but he was an expert on artwork. And what happened is a group had bought a painting that they thought was a Russell original. Okay, and they paid big bucks for it, like $400,000. And O.C. Seltzer's grandson or son said, that's not an original. Okay, and so when they turned around to try to sell it, and he had expressed that, they got less money, or were going to get less money. I don't know if they sold it. Instead, they went after O.C. Seltzer's son or grandson, and they said all kinds of bad things about him, and they tried to discredit him and tried to make him look horrible, so that and said he wasn't an expert, and said he didn't know what the hell he was talking about, and all those other things, right? So that their painting then would still be considered an original, right? Because they're discrediting the guy that says it wasn't. Well, he won, proved that he was who he said he was, an expert, and then also proved that, in fact, the painting was proved beyond a shadow of a doubt that the painting was, in fact, a fraud, was not a Russell original. And so he sued, the people that had bought that painting for defamation. because his reputation as an expert was seriously questioned, at least during that period of time. And he was successful. He won a decent lawsuit against him. So not only did they have a painting that wasn't an original and wasn't worth much money, they also lost a lawsuit to this Seltzer grandson. Common law business torts, and these come up on the next one, so we'll really talk about those. These are the common law business torts: injurious falsehood or trade disparagement. Just think of publishing, or maybe subversely saying bad things about your competition. Maybe use a pseudonym and get in on Facebook, and you're Burger King, and so you get in there and tell how Wendy's, their bathroom's dirty, or you saw all their employees, going to the bathroom and not washing their hands, and you start putting that kind of stuff on Facebook, and you're the Burger King manager, and boy, if they find out, right, that's injurious falsehood, or certainly trade disparagement. So intentional interference with contractual relations, I think the book gives a good example about that, is that if you try to steal employees that are under contract, okay, they're under contract with another organization, and you try to swipe them away, if they actually have a contract period and whatnot, that can be an intentional interference with contractual relations. And it can happen otherwise. I think the book also gives an example of a merger maybe that was going to take place, and a third party kind of tried to intervene and tried to stop it because they wanted to buy this company, and so they might have used trade disparagement and done those types of things. They interfered with some of these contract things, and that could in fact then be, it's common law or business tort. It would be tort behavior. Cyber torts, kind of a new thing again, right? Certainly defamation, and go back to even using Facebook and those types of things. We could defame people and cause them real harm. Again, telling the truth may be okay, if as long as what you're saying is the truth. If in fact you went to the bathroom at Wendy's or Burger King and you saw that their employees were not washing their hands, and that's what you expressed, and it was absolutely the truth, okay, right? They can criticize you all they want, but they shouldn't be able to get you for defamation, right? Intentional infliction of mental distress. Again, my examples of that are with older people or people that are of maybe developmentally disabled or whatnot, and folks taking advantage of them and inflicting mental distress upon them. Spouses also, some of those types of things. Hackers, misappropriation of trade secrets, is what it is. And then fraud, of course, existing in the cyber world, can be easy to do. There's a case, it was after the internet first kind of got going, I can remember, and people were just starting to kind of access the internet for information about investing in those types of things, and a couple guys kind of started this blog, and they were giving investment advice and and it was going along pretty good. Well, they themselves invested heavily in this one stock that was really cheap, just a startup kind of a stock, and it was penny stock, they probably called it, meaning that buying it didn't cost that much. Well, then in their blog, they really started touting the virtues of the stock and saying how wonderful it was and and they were making up stuff. But the stock price went higher because people were reading their stock and reading their blog and buying the stock, so the price kept going up, and they sold out, made a lot of money, millions of dollars each. But they got caught, right? And they'd committed a cyber fraud. They were putting out their information that was false, and so they got caught. Negligent torts, right? Unreasonable behavior that causes injury. Again, driving unsafely, failing to stop at a stop sign, exceeding the speed limit, right? We all have a duty of care. So these are the four elements that are required. Know the four elements, okay, for negligence to take place. So duty of care, you breach that duty, okay? That breach causes harm, causes an accident, causes something like that, okay, causes harm and damages. And the causation could be both, what they say here is fact and proximate, or maybe direct and even kind of indirect, right? Is approximate means that you could imagine that it was happening. So if two cars crash and certainly there's damage to both vehicles, but if a wheel pops off of one and rolls over and hits a bystander, okay, that would be causation too, the negligence. It wasn't a fact as to the actual accident, but it was proximate to it, and so that would be a negligence too. And that person that got hit by the rolling wheel would certainly be entitled to some compensation as well, right? So negligence, and again, we got a duty, things we talked about. Unreasonable behavior could be a person, an individual, but also professional. Okay, malpractice in terms of both attorneys, accountants. We're seeing more and more. We're seeing more and more attorneys, but what we're probably most familiar with is malpractice with medical professions. Or unreasonable behavior, right? Breach of the duty. Go back to most of these are car accidents. So it's driving too fast. It's failing to stop. It's exceeding the speed limit. It's any of those things, right? Causation, in fact, and that's kind of what we talked about. That's the actual accident itself, and then proximate causation is those things that could happen otherwise. You get away from that, the person that stumbles over the curb that's 2 blocks away because they heard the crash and that kind of drew their attention away. Yeah, they may have a tougher time proving. So defenses, right? So we defend, sometimes, and there can be contributory negligence, right? Well, I might have gone through the stop sign. The guy coming down the street the other way was driving 3 times faster than the speed limit. Okay, so who is most at fault there then? And that's actually where we get into comparative responsibility. Okay, or contributory negligence. So maybe my failure to stop at the stop sign ended up being 60%, and the person driving too fast is 40% responsible, and maybe that's the determination of a jury. Okay, that could reduce the amount then of the award, even the compensatory award in that case. Okay, it could reduce that amount because the other person might be accountable for their failure to exercise due care as well, right? Okay, but there'd probably still be some money that exchanges hand to be based on a formula, a pro rata, based on what they might determine to be the comparative responsibility in states that have comparative responsibility laws. That's not true of all states. I do believe Montana is a comparative responsibility state. Assumption of risk, and we put those things out there, right? When you involve yourself in an activity that can be somewhat dangerous, you probably, you might not even know it, but you're probably signing something that says, hey, you assume a certain amount of risk, right? And usually what that means, and since I'm a skier and involved in ski hill and whatnot, is, if you're skiing and you're on the normal slope, and you take a tumble, and it's a groomed slope, and it's just kind of normal conditions, and you take a tumble, and maybe you hit your head and get concussed. That's a risk that you do in fact assume. Now, on the other hand, if you're skiing and you're on a normal slope and it's groomed and whatnot, but all of a sudden you hit a tree stump, that's sticking out just a little bit, and you tumble and get hurt as a result. Is that an assumption of risk? Well, no. They might. You would certainly have a case that the ski hill, the ski patrol, whoever, should have probably marked off that particular hazard, and it would be a good case. In other words, they can't unload all of that. They can't say, hey, we're absolving ourselves of any possible legal action against us, even if we're negligent. They can say that, but it wouldn't hold up in a court. So strict product liability, unreasonably dangerous or defective products. And I'm going to give you the one example that I know of. Talking to some folks is in our area, and it's the BNSF. Train goes down the track, and it's got metal wheels on metal tracks. And guess what happens? A lot of times that kicks out sparks. Sparks sometimes cause fires, especially in dry years, and fires burn things. And the BN is just strictly liable, right, when they start a fire. And they know that, and it probably actually saves a lot of parties a lot of money, because BN shows up and they negotiate an amount and write a check, and away you go. And I had customers who had haystacks burn up, for example, because the fire went far enough and it burned their haystack and might burn up some of their grazing. And to my knowledge, most of the time they got along fine with the railroad. Didn't end up being a court case. They'd negotiate some kind of settlement and away they go. But in defective products, right, there can be a production defect. So there's something wrong. There's the big one that's going right now, and we don't know what the problem is here, but it's one of these two probably, is the Samsung Note 7, right? What's happening with them? Damn things are starting on fire. Okay, is it a production defect? My guess is it's probably a production defect, meaning that they're probably getting a battery from another supplier and putting that into that Note 7, and the battery's overheating or whatever. Okay. It could be a design defect, right? It could be that they didn't design it correctly. Maybe it's drawing more power, to a certain area than they anticipated, and it's overheating and causing the fire. It could be either one of those, right? Okay, and I don't know which. We'll probably find out over time. But either one of those, of course, is a dangerous or a defective product. And is Samsung going to be held strictly liable for damages that are caused by those things burning up? Oh yeah. Okay, and then a warning defect is just not warning people, the dangers and whatnot. And again, you'll see that you'll see that in both in products. You'll see that in like again, the ski hill thing. You're not putting up a boundary sign. This is the boundary. You can't go out of here. Those types of things. So. Respond to its superior's scope of the employment, meaning, right, in strict liability, that the business is going to be held accountable for the actions of the employee when it's deemed that employee is acting within the scope of their employment. Long words, right? And that's very broadly, again, that's probably very broadly defined. Changes in the law may change some of that a little bit, okay? Ultra hazardous activity, they're going to be held strictly liable. Think of people that use dynamite to blow up rock walls where they're building roads and whatnot. If a rock flies from 100 yards further than they thought and takes a window out of a house, obviously they're going to be held strictly liable for fixing that, right? Other strict liability. So dram shop acts, I know that one, that'll be on the test, right? Tavern owners liable for intoxicated patrons. And that's true, and we've all seen that. What can be their defenses? Some of them might be, God, we only served them, one drink. They were already hammered when they got here or something. Of course, that's probably not a defense. You're supposed to notice that they're hammered and not give them another drink, and on and on. It might be that we didn't serve them anything. We told them they were hammered and didn't serve them anything. Who knows? But dram shop acts are enforced. That's why bartenders go to get training and do all those other things. Okay. Common carriers, so truckers, railroads, those types of things, damage to goods being transported, they're held strictly liable, right? Except if it's acts of God. Okay, so storms, those types of things that could happen, actions of an alien enemy. We don't often think of those happening here, but think of some of the terrorist activities that could happen and have happened. Order of a public authority, so closure of a port or closure of railroad tracks because they're considered dangerous, or the weather. We've closed roads and stuff maybe because of the weather, right? Inherent nature of the goods. So if we're shipping something that is inherently volatile and might blow up or something while we're shipping it, right, the carrier itself may not necessarily be held strictly liable if in fact the goods themselves blow up or do something, right? or misconduct of the shipper, and in that case, the company that's shipping. So they didn't package it correctly or as they agreed to, or anything like that. So it kind of damages. Again, just two types of damages. There's actually a third type that we don't talk too much about here, but the two types are basically compensatory and punitive. And compensatory never gets talked about in terms of tort reform. Okay, everybody that I know of and everybody that I read and whatnot agrees that if somebody's damaged due to the actions of another, they should be, and they prove that, they should be fully compensated. They should be made whole. Okay, and that's what compensatory damages are. Now, there are some of these that are difficult to calculate. There's no question about that. And that sometimes gets discussed, and we'll talk about that here in a little bit. Punitive damages, on the other hand, are used to punish defendants, and punitive damages are the big ones that we read about often. It's the $20 billion case, against R.J. Reynolds Tobacco Company, or whatever the case may be, because they didn't properly warn smokers that they were going to die from smoking or whatever. Okay, they're typically the big awards that we see. Often the punitive awards end up being smaller than what the actual awards. Often the actual amount paid ends up being less than what the headline number was. It gets negotiated, while they're going through appeals and all those other things. So again, compensatory damages, compensation for injuries, right? So we got past, future medical expenses. Those are pretty easy. Generally speaking, you get the bills from the doc and you turn them over. If somebody caused the accident, boom. Past or future economic loss. So so if you're out of work, for 6 months because you got rear-ended by, somebody who was stupid and driving too fast or tailgating you or whatever, okay, they're going to have to pay you for their insurance, or they are going to have to pay you and compensate you for the time that you lost at work. Past and future pain and suffering, and this is where the calculation gets kind of difficult. So, it's truly a compensatory thing. What do you, if you got rear-ended like that and you did suffer a neck injury, and you're out of work for 6 months, and that's easy to calculate, but how do we know it's not going to come back? How do we know that's not going to cause some pain and suffering in the future? Okay, and usually attorneys for insurance companies and whatnot want to do a one-time settlement. They'd rather have you sign off and say, okay, I'll accept $250,000, and I agree then that no matter what happens in the future, I'm not going to come back against you. Okay, versus kind of leaving it open, kind of saying, no, I'm glad you paid for my hospital care and for my 6 months off work, but I'm afraid that this could go backwards in the future, and I just as soon, just leave it at that. Okay, and the insurance company could be on the hook, or the defendant could be on the hook, okay, for who knows, number of years, indefinitely, really. Okay, but those things are difficult. You've got emotional issues too, that can create all kinds of problems in terms of calculating what the losses and whatnot are. So, difficult things. Punitive damages are used to punish, right? If the negligent behavior was gross, so it's just so overwhelmingly negligent, right? Willful and wanton. We ignored warnings from experts, those types of things, right? We just kind of ignored those. We said, to hell with it. We're going to go about our way. And that could happen in the Samsung thing. We've seen that in the past with the most famous one is oftentimes the Ford Pinto. They made this Pinto. They had gas tanks that, when cars were rear-ended, the gas tanks would often split open, and the gas tanks and the contents, gasoline, obviously would explode, and it would kill people. Well, they found out in the course of the trial and the investigation was that Ford knew about that. Okay, and they ignored it, and they didn't just ignore it. They actually had done actuarial studies and determined that the amount that they would pay out in claims was going to be less than what it would have cost them to fix the problem, right? That's gross. Okay, that's willful and wanton negligence in that case. So we got we've got some tort reform ideas and some parts of the law here that you definitely need to know too for test purposes. But so we might not allow actions against retailers or wholesalers unless the manufacturer is insolvent. Now that's not saying that if the retailer did something to the product themselves, maybe they put it together improperly or something, obviously they'd still be held accountable. But if they're simply selling, if Walmart's simply selling the super duper barbecue, made by whomever or something, then the super duper barbecue blows up, Walmart, what this thing would be is saying, hey, you can't sue Walmart, you got to sue Weber. Okay, as long as Weber's still solvent. No recovery for defective design. I don't get. I haven't read about that. I probably should just take that out because I don't know of tort reform that really anybody looks at that. I mean, should we not allow recovery for the Note 7s that were designed improperly? No claims against sellers if the product is modified by the user. Yeah, that one, certainly would have some merit, right? There were cases, automobile cases, where people had, gone in this years and years ago, but people had modified them to make them go faster, right? To make them do things that they weren't originally intended to do, and then when they did those things, the people wrecked, and they blamed it on the car manufacturer. And sometimes that was well, they didn't warn us. They didn't warn us that by modifying the car, to make it go 150 miles an hour, that it might create problems. Okay, and so there's been some backlash against that, but I don't know that we've made a lot of movement on that. State of the art is more of a and it would be a type of reform, but it's also a type of a defense. It's saying, hey, we made something to the standard of the day. We made it as well as we could at the standard of the day, and granted those standards have changed, and think of the progress they've made even with automobiles in terms of the airbags, the automatic braking, those types of things. So if I'm driving a 2010, say, I don't have anything that new, but if I was driving a 2010 vehicle and I rear end somebody, could I go back and sue and say that gosh, it doesn't have automatic braking? Well, I could sure sue them, but their argument would be, hey, we made it state of the art, right, in its day. Okay. Statute of repose, and this one has actually, I've seen this one put into effect, and the statute of repose says that after a certain number of years that you own a product, past its normal life, you shouldn't be able to go back and sue the manufacturer. And the one that I saw that this actually came into effect, it was a specific example, but small airplanes in the U.S. they'd completely shut down the manufacturing of it because of the tort that was happening, and what was happening was anybody that went up in their 1954 Super Cub or whatever, and the 1954 Super Cub crashed, and it turned out that it had some the wings had started to go to hell, or some of the struts or whatever they have on those things that started to crack, and they had some problems in it. And 50 or 60 years after the fact, people were suing the company that had made the airplane and winning. Okay, and winning. And finally Congress, and it decimated the small aircraft manufacturing in the United States. All of them had basically closed up, I think, maybe except one. We just didn't make them in the U.S. because you couldn't handle that type of legal environment. And so the Congress passed a law on airplanes and said, hey, 25 years, right? If you own it past 25 years, you're kind of on your own. We can't expect these planes to be sound forever, right? There's got to be kind of a limit. And so they said 25 years for airplanes, and they may have done this for other products, but I'm not familiar with it. That was kind of the big one that I remember. So, and reduce or eliminate punitive damages. And we do see a lot of calls for this. Probably more so for malpractice, especially medical malpractice, is where we'll see a lot of calls for the reduction of punitive damages. And part of that is that it's obviously one of the things that's driving our healthcare costs up is people get the wrong knee operated on, and they get a $3 million award for that. $50,000 of that award is for getting their right knee surgically repaired and whatnot, and the rest of it's all punitive damages. Well, some people argue that might be too much, and it's certainly driving up the cost. So, alternatives to tort, disadvantages, right? One of the disadvantages is that the lawyers can take these cases on a contingency, so it doesn't really cost the plaintiff any money, and they don't have anything at risk. The lawyers do, but the plaintiff doesn't, right? And the lawyers make a lot of money then. And in fact, when you see a lot of these lawsuits and whatnot, you'll see especially some of the class action ones that I've seen. It's interesting. A couple of them that I've been involved in. Our compensation for one was a $2.50 gift certificate, and our compensation for another one literally was 25 cents. We got a check for 2 bits. Okay, but when you read the settlement terms, the attorneys in each case that handled those cases got millions of dollars. Right? Well, there was only one attorney. There was a gazillion plaintiffs, right? And so, the award was spread over all the plaintiffs. The attorneys themselves got a bunch of money. So, one of those things. Alternatives, certainly arbitration, and we're seeing more of that. Certain states have no-fault insurance for vehicles, right? So if you're in a wreck, your own insurance company just takes care of it, and that way we don't have the tort thing. And that could happen, could be the case with other maybe types of things, but primarily with automobile. And workers' compensation we see, I think, in most, if not all, states where that's kind of a no-fault insurance deal too. Or if I get hurt at work, right, unless I intentionally cause that hurt myself or that accident myself, intentionally cause it, I'm going to be covered, okay, for workers' comp. So if I trip walking out of my office and bang my head or something and have to go to the doctor, that should be covered under the workers' comp program. Okay, no matter if it's my own stupidity in that case or something that my employer may have done or not done. Okay, it doesn't matter, and that again, it saves a lot of hassles of suing, me having to sue the college or whomever and say that there was a problem. So workers' comp, talked about that, right? Protect employees and families. Employer acted unreasonably. That doesn't have to be the case, what I said. I'm not sure. I think what this is saying is that this is maybe why they got put into place. Okay. Because in past, maybe employers had acted unreasonably and they weren't covering those types of things. And you could certainly set up systems that would, cause employees not to be compensated and whatnot. And so we ended up with workers' compensation. And defenses, again, can be assumption of risk, contributory, but in Montana, at least, we don't really have any of these. And so I don't really look at these in terms of workers' comp because ours is a no-fault system of workers' comp. And maybe that differs in other states. Again, so maybe my knowledge here is just limited to the state of Montana, but in Montana, it's basically a no-fault system, right? As long as neither side was intentional in their conduct. Then if something happens, the workers' comp, the insurance that's set up, employers are responsible for paying into a workers' comp fund on behalf of their employees, actually, for that very reason. So test for compensation, again, if it's an injury, if it's an accident, and result of the employment. And again, consider very, very broadly, and if you remember the story that I told you, that was a workers' comp case about the cop that fell over the railing at the motel in Great Falls to his death. Way out of what I would call way out of normal work conditions, but was considered to be within the scope of the employment, and so the family was in fact compensated. The thing about workers' comp is that it's an exclusive remedy. So if I don't like my award, I can sue workers' comp and say that's insufficient. You're not properly judging my injury, my future pain and suffering, those types of things. I can sue workers' comp, but I don't get to go after my employer in those cases. Ooh, look at that. Many states have enacted or considering laws classifying certain breeds of dogs as dangerous. Rottweilers, Dobermans, Pit Bulls. Okay. If you owned one of those breeds, are you comfortable knowing that you might be strictly liable, right? If your pet decides to bite somebody. Ooh, kind of interesting, right? So no, even if it was the little kid over playing in your yard, and they shouldn't be in there. And you let the dog out the back door not knowing that the little kid's in the front. Okay, right? And so, those are the types of defenses that you would have, but obviously this kind of thing would take it away. Say, I guess if you own a menacing dog, you're going to be held liable. So there we have torts, chapter 10.